Child Protective Services, and they won't give them back to their loving families because they're making money.
This is a legal system that you're going into. And if you don't know the rules, you will be chewed up and spit out.
If I could say anything to a mother who just got their children detained, you're in a crisis. Yeah. Life feels like it's over. The most important thing is regaining custody of your children.
The child welfare system at its core is designed to protect children who need protection, okay? And that's key, is who need protection.
So social workers, out of fear, will remove more children rather than only remove those children that truly need to be removed.
It's okay. It's okay.
This isn't someone stole your car. Someone broke into your house. This someone took your child, your flesh and blood.
It doesn't say on this order that it was not proven. It says untrue. True. I immediately knew that, okay, well, this ain't over.
Were there signs there? Were there no signs? Did I miss them? Did I catch them? At this point, I honestly don't know.
Families only get a finite amount of time to reunify.
I came into this field to help families, not destroy them.
The difference between the criminal system and the child welfare system is substantial. You have more rights as a criminal than you do as a parent.
Hello, everyone, and welcome to CPS Current Events. I'm your host, Amanda Cisco. I also host Fight CPS's Civil Rights Struggle every Thursday. I hope everyone is having a wonderful day today. I wanted to start off today by saying that there has been something brought to my attention that there was a disgruntled ex-host that may be causing some issues. So if you guys come across any of those disparaging remarks, please disregard. And other than that, we will keep moving. I will be talking about a couple of CPS cases going on today, and we'll be talking a little bit about a new book that came out that might be very helpful to you guys, and we will be playing a couple of videos. Now, the first thing that I want to get into is a case called Peterson v. Child Protective Services. This was filed in April 2010, and Charles Simpson III, the district judge, said in his memorandum, plaintiff Karen Peterson filed a pro se complaint against Child Protective Services and Jefferson County Public Schools. This matter is before the court on preliminary review of the complaint pursuant to 28 U.S.C. Section 1915E. So that's not a civil rights lawsuit. So 28 U.S.C. 1915E is a subject to the subsection B. Any court of the United States may authorize the commencement, prosecution, or defense of any suit, action, or proceeding, civil or criminal, or appeal therein, without prepayment of fees or security therefore, by a person who submits an affidavit that includes a statement of all assets such prisoner possesses that the person is unable to pay such fees or give security therefore. Such affidavit shall state the nature of the action, defense, or appeal, and the affiant's belief that the person is entitled to redress. Okay. So this case was based on McGore v. Wigglesworth, 114 F3D 601 in the Sixth Circuit, 1997. For the reasons that follow, the instant action will be dismissed, unfortunately. Plaintiff used a court-supplied general complaint form to initiate the lawsuit. Okay. Under the section of the form directing plaintiff to state the grounds for filing the case in federal court, plaintiff states, violation of IV and XIV constitutional rights amendments infringement, intimidation, reprisal. Plaintiff alleges that on March 8, 2010, a worker from CPS went to her daughter's high school and questioned her without an adult or parent present. Plaintiff alleges that the worker claimed that a hotline call was reported, that the mother, I, was mentally ill, and that she was too, and I was accused of medical abuse because she wasn't taking her medications for mental illness. Plaintiff claims that neither she nor her daughter has ever been diagnosed with mental illness by a clinical psychiatrist and that they do not take any medications for mental illness. So this is a case of complete fabrication of evidence, okay, where CPS used this as an opportunity to use this public school as a farming ground to get her high school age daughter. Plaintiff further alleges that her daughter's father called from Minnesota saying that they were going to put her into custody if he didn't come to take her home with him. And this is a classic manipulation tactic where they drag other family members and give them ultimatums, and they are forced to make very difficult decisions, to protect their children from being, foster care victims. Okay. Sorry, guys, I lost my place. All right. Plaintiff further alleges that her daughter's father called from Minnesota saying that they were going to put her into custody if he didn't come to take her home with him. Plaintiff claims that CPS has never produced any documents to support these claims. Plaintiff alleges that she has had several encounters with false claims, and this was another form of harassment and intimidation. She avers that she had several encounters with false claims, and this was a form of harassment and intimidation. Plaintiff states that schools are learning institutions, not a place to interrogate and violate children's constitutional rights, which she has a very good point. In her prayer for relief, the plaintiff demands $100,000 in punitive damages, $100,000 in damages for emotional distress, and remedy to stop harassing my children in the school without counsel or parents. Because plaintiff is proceeding in forma pauperis, this court must review the instant action. 28 U.S.C. 1915E, McGore 114 F3D at 60809. Upon review, this court must dismiss a case at any time if it determines that an action is frivolous or malicious, fails to state a claim upon which relief may be granted, or seeks monetary relief from a defendant who is immune from such relief. So they're using loopholes in the law to dismiss her claim. We're going to be learning from the successful suits as well as the ones that were not successful, because it's just important to learn what not to do. So the parties. First, the court notes that the complaint lists as plaintiffs Peterson and Jakara Strader. Strader is apparently Peterson's daughter. However, Strader did not sign the complaint. See, guys, pay attention because we're learning. And I'll be posting this action in the page, as well as the Marsden motion, which I wasn't able to get on the page last week. So I'll be putting that on today. Okay. Strader is apparently Peterson's daughter. However, Strader did not sign the complaint. See Federal Rules of Civil Procedure 11A. Every pleading, written, motion, and other paper shall be signed by the unrepresented party. Peterson does not have standing to assert any claim on behalf of Strader. CEG Shepard v. Wellham, 313 F3D 963 970, 6th Circuit 2002. Pro se means to appear before oneself. Thus, one person may not appear on another person's behalf or in the other's cause. Gonzalez v. Wyatt, 157 F3D 1016 1021, 5th Circuit 1998. In federal court, a party can represent himself or be represented by an attorney, but cannot be represented by a non-lawyer. Therefore, the only proper plaintiff in the action is Peterson. Moreover, in a civil rights action, parents cannot appear pro se on behalf of their minor children because a minor's personal cause of action is her own and does not belong to her parent or representative. Shepard, 313 F3D at 970, a Section 1983 action citing Chung V. Youth Orchestra Foundation of Buffalo Incorporated, 906 F2D 59 in the 2nd Circuit 1990. Okay, Meeker v. Creature. Okay, so it just goes on to state like a bunch of cases that they cited, which is very important for you guys to do your legal research and cite the controlling case law that affects the outcome of your case where you're pleading. Okay, and again, disclaimer, I am not a licensed attorney. I start law school next fall. I'm not giving any legal advice. I'm simply providing avenues to legal education of which we all have the right to receive. Okay. And under Federal Rules of Civil Procedure 17C and Article 28 of the USC Section 1654, a minor child cannot bring suit through a parent acting as next friend if the parent is not represented by an attorney. Therefore, Peterson, a non-attorney, cannot bring this action on behalf of her minor child without legal representation. Should Peterson wish to pursue claims on behalf of her child, she must obtain counsel. In Section B, this is where it talks about 42 USC 1983, which is civil rights, federal civil rights lawsuits. Okay, so in Section 1, titled CPS of Article B in this complaint, it states, although not so specified by plaintiff because she alleges claims of constitutional violations against CPS, the court construes this action as being brought under 42 U.S.C. Section 1983, Thomas v. Shipka, 818 F2D 496 500 6th Circuit 1987, vacated and remanded on other grounds, so that law is no longer applicable. And another case, 488 U.S. 1036 1989. It is unnecessary and needlessly redundant to imply a cause of action arising directly under the Constitution where Congress has already provided a statutory remedy of equal effectiveness through which the plaintiff could have. So sorry, guys. Sorry about that. All right, things have been really crazy for me today. All right. Section 1983 is the remedy that they are referring to. Section 1983 creates no substantive rights, but merely provides remedies for deprivation of rights established elsewhere. As such, it has two basic requirements. One, the deprivation of federal, statutory, or constitutional rights by, two, a person acting under the color of state law. And this can cite West v. Atkins, 487 U.S. 4248 in 1988, Flint v. Kentucky Department of Corrections, 270 F3D 340 and 351, 6th Circuit in 2001. All right. Absent either element, no 1983 claim exists. And this was determined by Christie v. Randelet, 932 F2D 502 and 504, 6th Circuit 1991. Okay. In the instant case, CPS is not a person acting under color of state law for 1983 purposes. See Will v. Mitch, Department of State Police, 491 U.S. 58 and 71 in 1989. Plaintiff, therefore, fails to state a claim for relief against CPS. Additionally, a state agency may not be sued in federal court unless the state has waived its sovereign immunity under the 11th Amendment or Congress has overridden it. Okay. All right, and then it cites more case laws. You guys will be able to look at these when I post this complaint. In enacting 1983, Congress did not intend to override the traditional sovereign immunity of the states. Okay, therefore, the claim against CPS is also barred by the 11th Amendment. Accordingly, plaintiff's claim against CPS will be dismissed for failure to state a claim upon which relief may be granted. All right. Now, part two is the public school. Plaintiff's claim against JCPS also fails. The complaint makes no reference to JCPS except in the portion of the complaint in which defendants are to be listed, and makes no allegations concerning any action taken by JCPS. While the court is aware of its duty to construe pro se complaints liberally, plaintiff is not absolved of the duty to comply with the federal rules of civil procedure by providing defendants with fair notice of the basis of her claims. To state a claim for relief, plaintiff must show how each defendant is accountable because the defendant was personally involved in the acts about which she complains. Because plaintiff has not alleged any facts involving defendant JCPS, the claim against it will be dismissed for failure to state a claim upon which relief may be granted. Moreover, to the extent plaintiff seeks to hold JCPS liable based on any supervisory authority, the doctrine of respondent superior or the right to control employees is not a proper basis for liability under Section 1983. Nor can the liability of supervisors be based solely on the right to control employees or simple awareness of employees' misconduct. In order for supervisory liability to attach, a plaintiff must prove that the official did more than play a passive role in the alleged violation or showed mere tacit approval of the goings-on. In other words, liability under Section 1983 must be based on active unconstitutional behavior. Plaintiff has alleged no such active unconstitutional behavior by JCPS, and JCPS is not liable for the actions and inactions of its employees. Therefore, plaintiff's 1983 claim against defendant JCPS will be dismissed for failure to state a claim upon which relief may be granted. Okay, now this is the last section C, state law claims. To the extent that plaintiff is seeking to pursue any state law claims, the court declines to exercise supplemental jurisdiction over those claims. Section 1367C of Title 28 of the United States Code provides in pertinent part as follows. The district courts may decline to exercise supplemental jurisdiction over a claim if the district court has dismissed all claims over which it has original jurisdiction. And that is 28 U.S.C. Section 1367C3. Having dismissed all federal claims over which the court had original jurisdiction, the court declines to exercise supplemental jurisdiction over any remaining state law claim that plaintiff may be attempting to bring. Consequently, the state law claims will be dismissed without prejudice, meaning she can bring the case again. The court will enter an order consistent with this memorandum opinion. So basically, to explain the outcome of this particular complaint, and if anybody put up a comment, I'm sorry I wasn't able to see it. But this particular complaint, the courts weren't wrong in their decision. So in the complaint itself, which I will try to find and post along with it, it did paraphrase a lot of it. When you bring a case into federal court, your memorandum must be on point. You must do your legal research, and you need to make sure that you know the federal rules of evidence and the federal rules of civil procedure. Even though these trial courts are a travesty to our democratic republic and our constitutional rights, and they don't follow any of the rules, federal court is very different. It is very different. You need to have all your ducks in a row. You need to know what you're doing. You need to know what you're talking about. And if you don't, you need to hire an attorney or do your due diligence. And that is going to take a lot of hard work. You're going to get tired. Your brain's going to want to explode. I've been studying the law for years. I've been reading the law for years. And I still, the more I learn, the more I realize, the less I know. You never stop learning in the law, which is why it's also important to specialize. But, a typical memorandum in federal court could be anywhere from 30 pages to hundreds or more. And these federal judges are very to the letter of the law. I mean, we're talking about, big numbers. You have to have a minimum of $75,000 in damages just to enter federal court. That's of the lowest level. And a lot of these cases are very serious. A lot of these accusations are very serious and have consequences, not just on the individuals, but on the city, on the state. And they're very, very expensive to litigate, which is why it referenced that she filed the above motion at the beginning to waive the filing fees. So in my jurisdiction, just to file a complaint in federal court is $600. And it just, the legal fees skyrocket from there. I mean, discovery costs money, serving parties, subpoenas, all of this costs money. Taking up the court's time, that costs a lot of money. So when people are trying to figure out why is my retainer fee so high, well, this is why. Litigation is so very expensive. It's a liberty, going to court is a liberty that all of us are entitled to, but there are costs associated with that. There are avenues to get around that if you can prove, that there's reason for them to waive those fees, or at least in the beginning, so you can get your case on the docket. They do their best to work with everyone. But federal court we're dealing with the big dogs. So, I would go so far as to say that this complaint is, her education was not very dense in the law and in what she was doing. The complaint that she drafted wasn't very well written either, as the judge pointed out, and it was missing a lot of necessary information. In order to, and I've talked about this in previous shows, you have something called a cause of action. A cause of action is the right to sue. To meet the elements of a cause of action, and there are three, there has to be 1, a duty, and then 2, a breach of that duty. And then as a result, 3, damages resulting from the breach of that duty. And just because your case meets all those elements is one thing, but once you establish that, yes, this complaint meets the 3 elements of a cause of action, you then have to prove those elements. And the burden of proof is on the party who asserts a claim or demands redress. Always. So that is Peterson v. Child Protective Services. It was an unsuccessful complaint. I hope she had success in the future, maybe filing through state court or hiring an attorney who was able to write a better memorandum. Because a lot of times when you take a case to federal court, there's not really going to be a trial. You submit all of your evidence that was in state court, all of the transcripts and your memorandum with very extensive legal research, and you have to take your time and you have to be very, very specific in these memorandums, because a lot of the times once you file in federal court, the judge will simply just read all of the information and make a decision. A lot of times there's not a trial. So something to keep in mind. All right. So another case, this is in my state. All right, this is our second case, and then we will go into a couple of video treats that I have for you guys today. Okay. So case number 2 is Mercer v. Fairfax County Child Protective Services. Okay. All right. So Gregory Sean Mercer, plaintiff v. Fairfax County Child Protective Services. All right. And Liam O'Grady, United States District Judge, writes his memorandum opinion as follows. Okay. This matter is currently pending before the court on motions to dismiss by several of the defendants, and expect a flurry of motions in return anytime that you file a complaint. Okay. Fairfax and the defendants filing for a motion to dismiss are as follows: Fairfax County Child Protective Services, Fairfax County Department of Code Compliance, Jack Blair, Elizabeth Perry, Tanya E. Powers, Letisa Tanks, Carrie Allender, and Kenneth Houts. The matter has been fully briefed. The parties, and on August 21st, 2015, the court heard an oral argument. For the reasons stated in open court, as well as those set forth below, the motions will be granted. So another case where the motions to dismiss were in fact granted. Let's find out why. Okay. Because this matter is before the court on a motion to dismiss, the following facts are drawn from the complaint and accepted as true. Toby v. Jones, 706 F3D 379 and 383, 4th Circuit, 2013. Many of the facts have been drawn from the exhibits attached to the complaint, which the court may properly consider so long as they are integral to the complaint and authentic. And that is based on a case, Anand v. Aquin Loan Servicing LLC, 754 F3D 195 and 198, 4th Circuit, 2014. Citations omitted. As is evident from the Mercer's allegations, the agency reports are integral to the complaint and authentic, having been received pursuant to his Virginia Freedom of Information Act request. And I've talked about FOIA requests with you guys. If you are getting a lot of backlash, getting certain pieces of information and evidence that you need for your case, you can go down to your local police department and file a Freedom of Information request. Well, Freedom of Information Act request form. You can also do it online. This controversy arises out of two unrelated incidents between a pro se plaintiff, Gregory Sean Mercer, and various government officials and entities in Virginia. The first event was a traffic stop that occurred on June 9th, 2006. In that stop, defendant Houts issued Mercer a summons for stopping on an interstate highway without having an emergency or medical problem. Mercer was given the summons to sign, and while he was signing, Hoots exclaimed, "You ripped the pen out of my hand." Hoots then removed Mercer from his car and called defendant Allender to determine if the trooper could arrest the plaintiff. Mercer was then arrested and charged with a felony assault of a police officer. The charge was later reduced to a misdemeanor. On March 27, 2007, Mercer was convicted of the misdemeanor charge after a 2-day jury trial. He appealed his conviction to the Court of Appeals of Virginia, which affirmed his conviction. He then appealed to the Supreme Court of Virginia, which dismissed his appeal. He subsequently filed a petition for a writ of I don't know how to say this name. Okay, certiorari with the Supreme Court of the United States. Mercer's criminal case was finally resolved on July 7, 2010, when the United States Supreme Court denied his petition for rehearing. As to the second set of events, in January 2013, the Fairfax County Department Code of Compliance began investigating a complaint that Mercer's home, in which his 2 children resided with him part-time, was unsanitary and hoarded. Ooh. This is getting interesting. Is it a case of retaliation, or do you think his house was really a hoarder house? Let's find out. On January 23rd, 2013, Letitia Tanks, a DCC employee, a Department of Child Services, well, DCC, went to the home to conduct an inspection. When no one answered the door, Tanks left a business card. Later that day, Mercer called Tanks and wanted to know the reason for her visit. Upon learning the reason, Mercer requested that Tanks call him back in 2 weeks to schedule the inspection, as he was going through a divorce. When she eventually called, Mercer informed her that he would not schedule an inspection until he received a response to his Virginia FOIA request for a copy of the DCC complaint. Sounds like Mercer might be getting a little cocky. You have to be careful when you deal with these people, because they can, and they often do, completely ruin your life. And unfortunately, they have the power and the immunity and the tools to do so. So when we're fighting back against our cases, we have to be careful. We have to strategize, and we have to play our cards just right. Okay. At some point, Mercer scheduled an inspection at FCDCC insistence. Okay. On March 5th, 2014, Mercer called DCC employee Jack Blair to reschedule the inspection. In this telephone conversation, Blair informed Mercer that he was notifying CPS, Fairfax County Child Protective Services, of allegations. The next day, the Fairfax County Child Protective Services social worker, Tanya Powers, went to Mercer's daughter's school to interview them. Within 2 hours, she arrived at Mercer's front door and requested to inspect the home. Mercer asked her if the inspection could be rescheduled, upon which she told him that if the inspection could not be conducted immediately, plaintiff's children would be removed from the plaintiff's custody and placed with foster care. Under duress and fearing for his children, Mercer consented to the inspection. During the inspection, Powers took pictures of the interior of the home over Mercer's objection for the benefit of the FCDCC. At the end of the inspection, she advised Mercer that she had concluded the allegations in the DCC complaint were not supported. Okay, so the claims that his house was a hoarder house turned out not to be true. Mercer was apparently very fixated on the whole complaint, on who the complainant was, but Powers informed him that she could not reveal the individual's identity. Powers then left the home, intending to unlawfully share her 11 photographs with the FCDCC at a later time and or date. Shortly thereafter, Mercer canceled the DCC inspection. A few weeks later, on March 25th, 2014, Tanks issued him a DCC notice of violation concerning the exterior of his house. Based on these events, on March 6, 2015, Mercer filed a complaint in this court alleging that the various Fairfax County, Virginia officials violated his rights under both the Virginia and the United States constitutions. Mercer subsequently filed 2 amended complaints shortly thereafter on June 1st, 2015 and June 11, 2015, respectively. Several defendants filed the instant motion to dismiss. Mercer then filed a motion for leave to amend his complaint yet again, which the court granted. On August 3rd, 2015, Mercer filed the second amended complaint that is now before the court with an added additional count of fraud against all named defendants, as well as a defamation claim against Houts, Allender, and the defendants who are members of the Virginia judiciary. Okay, so I'm going to pause right here. Let's see. This article is a little bit longer. And we do have some videos that we need to watch still. But this is something that I often see when I am talking with people and they're sharing their cases. This is also something that I have myself experienced when, you know, of course, like the whole situation is so upsetting. You know, you want to, like, you're under attack. You feel very vulnerable. You have your guard up. And naturally, your instinct is to attack anyone that comes off as a threat toward you. But unfortunately, a lot of times when we do this, we end up making claims and attacks against people who were never against us in the first place and who could have possibly been allies. So, you know, I'm not going to finish this article. I'm going to go ahead and post it. I would like to go ahead and get into our first video. And let me just see really quick if I can get that up. But just keep in mind, guys, you know, I want us to learn from these cases, and I want us to be able to identify, you know, what are things that will strengthen our case and our claims, what are things that will weaken them. And, you know, when it comes to a court case, when a judge is listening to your story, that's really like the most important part is the story. The story matters, and you have to have everything in line. and you have to write things a certain way. I mean, there's a reason why attorneys are so expensive. There's a reason why it's very important to hire one. Unfortunately, we can't always afford attorneys, and that's another thing that I wanted to talk to you guys about today. I have been pondering a lot about this issue lately, and the fact that legal fees are so expensive, and those of us who are targeted are mostly families who don't have the income to protect ourselves against these claims and these actions that are brought against us and our families and our children. So I'm a realtor, and I've disclosed this a few times before. And I work with, right now, the market where I am, it's insane. I mean, the inventory has gone down 40% in the last few weeks in my region, which is Southeast Virginia. And there is only a couple of weeks of inventory in the multiple listing service, the MLS, which is unheard of. I mean, this is literally unheard of. Interest rates are skyrocketing again. So there's just, things are crazy. Things are very crazy. And the rental market is even worse. And I work with a lot of clients who don't have great credit. And you've got, people who sell their home, and because of the inventory, they don't have a home to go into. And these are qualified clients, people with great credit scores, lots of money. They just sold their house. They got a lump sum. So they're taking away the rental market inventory from the renters who really need it. So yes, Grace. As soon as I wrap up this thought, we're going to start the video. So I've been working with a lot of people trying to repair their credit. I'm not a credit repair person, but, I'm partners with some financiers who do help with those things. And it kind of occurred to me upon pondering, it is really, really very important. If you can't afford an attorney, call a credit repair company. Start repairing your credit, start paying off things that are negatively impacting your score. And then if no other way, you can get your credit to a point where you can take out a loan and hire an attorney to get your kids back. It doesn't matter how much you study the law, how confident you are representing yourself pro se. I've been pro se my whole case. I've been very successful in litigation, but the outcomes of my case have not been very good. Basically, unfortunately, in what is supposed to be a democratic republic, if you walk into these courtrooms and say, I'm not an attorney, but I know my rights, I know the law, I demand the law be followed, follow the Constitution, they will laugh you out of that courtroom. It shouldn't be that way, but that's how it is. So it becomes an issue of pride versus your children and their well-being. What's more important? So food for thought, something to consider. Let's go ahead and play that first video.
Thank you, Mr. Chairman, members of the committee. I'm happy to be back in front of the Judiciary Committee where I started this pilgrimage. I am going to get even more fundamental than my good friend and colleague. Like him, I speak to students, especially law students, but also college students and even high school students, quite frequently about the Constitution. Because I feel that we're not teaching it very well. I speak to law students from the best law schools, people presumably especially interested in the law, and I ask them, how many of you have read the Federalist Papers? And well, a lot of hands will go out. No, not just number 48 and the big ones. How many of you have read the Federalist Papers, cover to cover? Never more than about 5%. And that is very sad. I mean, especially if you're interested in the Constitution. Here's a document that says what the framers of it thought they were doing. It's such a profound exposition of political science that it is studied in political science courses in Europe. And yet we have raised a generation of Americans who are not familiar with it. So when I speak to these groups, the first point I make, and I think it's even a little more fundamental than the one that Stephen has just put forward, I ask them, what do you think is the reason that America is such a free country? What is it in our Constitution that makes us what we are? And I guarantee you that the response I will get, and you will get this from almost any American, including the woman that he was talking to at the supermarket, the answer would be freedom of speech, freedom of the press, no unreasonable searches and seizures, no quartering of troops in hope, those marvelous provisions of the Bill of Rights. But then I tell them, if you think that a Bill of Rights is what sets us apart, you're crazy. Every banana republic in the world has a Bill of Rights. Every president for life has a Bill of Rights. The Bill of Rights of the former evil empire, the Union of Soviet Socialist Republics, was much better than ours. I mean it literally. It was much better. We guarantee freedom of speech and of the press. Big deal. They guaranteed freedom of the speech, of the press, of street demonstrations and protests, and anyone who is caught trying to suppress criticism of the government will be called to account. Whoa, that is wonderful stuff. Of course, just words on paper. What our framers would have called a parchment guarantee. And the reason is that the real constitution of the Soviet Union, you think of the word constitution, it doesn't mean a bill, it means structure. Say a person has a sound constitution, has a sound structure. The real constitution of the Soviet Union, which is what our framers debated that whole summer in Philadelphia in 1787. They didn't talk about the Bill of Rights. That was an afterthought, wasn't it? That constitution of the Soviet Union did not prevent the centralization of power in one person or in one party. And when that happens, the game is over. The Bill of Rights is just what our framers would call a parchment guarantee. So the real key to the distinctiveness of America is the structure of our government. One part of it, of course, is the independence of the judiciary. But there's a lot more. There are very few countries in the world, for example, that have a bicameral legislature. Oh, England has a House of Lords for the time being, but the House of Lords has no substantial power. They can just make the Commons pass a bill a second time. France has a Senate, it's honorific. Italy has a Senate, it's honorific. Very few countries have two separate bodies in the legislature equally powerful. That's a lot of trouble, as you gentlemen doubtless know, to get the same language through two different bodies elected in a different fashion. Very few countries in the world have a separately elected chief executive. Sometimes I go to Europe to talk about separation of powers. And when I get there, I find that all I'm talking about is independence of the judiciary. Because the Europeans don't even try to divide the two political powers, the two political branches, the legislature and the chief executive. In all of the parliamentary countries, the chief executive is the creature of the legislature. There's never any disagreement between them and the prime minister, as there is sometimes between you and the president. When there's a disagreement, they just kick him out. They have a no-confidence vote, a new election, and they get a prime minister who agrees with the legislature. And, the Europeans look at this system and they say, well, it passes one house, it doesn't pass the other house. Sometimes the other house is in the control of a different party. It passes both, and then this president who has a veto power vetoes it, and they look at this and they say, it is gridlock. And I hear Americans saying this nowadays, and there's a lot of it going around. They talk about a dysfunctional government because there's disagreement, and the framers would have said, yes, that's exactly the way we set it up. We wanted this to be power, contradicting power, because the main ill that beset us, as Hamilton said in the Federalist, when he talked about a separate Senate, he said, yes, it seems inconvenient, but inasmuch as the main ill that besets us is an excess of legislation, it won't be so bad. This is 1787. He didn't know what an excess of legislation was. So unless Americans can appreciate that and learn to love the separation of powers, which means learning to love the gridlock, which the framers believed would be the main protection of minorities, the main protection. If a bill is about to pass that really comes down hard on some minority, they think it's terribly unfair. It doesn't take much to throw a monkey wrench into this complex system. So Americans should appreciate that, and they should learn to love the gridlock. It's there for a reason, so that the legislation that gets out will be good legislation. And thus conclude my opening remarks.
All right. I don't know if we were able to finish that video. Give me 1 second. I think we're having technical difficulties. That was a very good video about separation of powers and checks and balances. So let me see if I can get with our producer and see if we can get that running again. Okay. All right, now while we wait on that, I will go ahead and kind of talk a little bit about the separation of powers. So the separation of powers, therefore, refers to the division of government responsibilities into distinct branches to limit any one branch from exercising the core functions of another. The intent is to prevent the concentration of power and provide for checks and balances. Now, what does this have to do with family court cases? Well, here's a free child custody civics lesson with citations to Alabama law. Know your sources. We call it separation of powers or checks and balances. You might find it helpful when dealing with the executive branch or the family courts, which is the judicial branch. More generally, okay, so in the Alabama Constitution, Article 3, Section 42A, powers of the government of the state of Alabama are legislative, executive, and judicial. B, the government of the state of Alabama shall be divided into 3 distinct branches: legislative, executive, and judicial. C, to the end that the government of the state of Alabama may be a government of laws and not of individuals, and except as expressly directed or permitted in this Constitution, the legislative branch may not exercise the executive or judicial power. The executive branch may not exercise the legislative or judicial power, and the judicial branch may not exercise the legislative or executive power. The impartiality of the judiciary, gosh, say that 5 times fast. The impartiality of the judiciary is a right of the citizens, not a private right of the judges. And this is in the Alabama State Constitution. In the matter of Marvin v. Wiggins, Circuit Judge, 4th Judicial Circuit of Alabama, 2009, said the juvenile court shall advise the parent, legal guardian, or legal custodian of the right to counsel and shall appoint counsel if the juvenile court determines he or she is indigent. Indigent, I believe in the legal term, means you cannot afford it. Okay. Bottom line, one of the reasons why DHR uses its leverage to get agreements outside of the court is to avoid oversight by the judicial branch and the absolute right to a lawyer that the Alabama legislature, the legislative branch, has established for you and your family. DHR has to follow the laws just like you do, and our system, when used correctly, is actually set up to hold everyone accountable to the same standards. But if you don't have a child custody lawyer, then you don't know what those standards are and what you can leverage to hold DHR accountable and navigate the family courts effectively and fairly. So that's just food for thought. Although this is for the state of Alabama, this applies to all states. Okay, another thing that I wanted to talk about, and we'll play the video of separation of powers again next week. Another thing I wanted to bring attention to is HB 2675. So I spoke to an individual who reached out after my last show. He wasn't able to make it today, but we hope to have him at some point in the future. There was a minor conflict that he had to attend to. So HB 2675 is, I think it just got introduced in this most recent session for Arizona. But basically, I will give you a brief rundown. Okay, so it requests that it be enacted by the legislature of the state of Arizona. Section 1, Title 8, Chapter 4, Article 8, Arizona Revised Statute is amended by adding Section 8-818 to read the right to jury, jury demand and hearing, applicability. Okay, so a party has right to a trial by jury, and that right might not be arbitrarily denied. And this is, I'm reading an addendum right now. The court shall provide written notice to all parties of the right to a trial by jury prescribed by this section. Often, when juries are requested, they are denied. The party is denied a right to a jury trial, saying it's overly burdensome and some other such arbitrary and capricious applications of the law, according to the people who are running these courts. Okay, if the court fails to provide this notice, any subsequent proceedings or rulings do not have the force of law. So, if your right to a jury is denied, then, you know, basically the proceedings and rulings thereafter do not have the force of the law because your due process rights were violated. Or B, if a party believes that the party's rights have been substantially violated by the orders of the court and files a jury demand with the court within 20 days after the court's orders are filed, the court shall set a new hearing before a jury within 20 days after the demand is filed. A party may have the jury re-examine discrete portions of the court's orders without the entire case being relitigated or re-examined. And C, this section applies to matters before the court for a preliminary protective hearing pursuant to Section 8-824 or any other hearing for the termination of that parent-child relationship. So yes, I don't think that we should be explicitly leaving these huge life-changing decisions up to one single individual, one judge that has absolute immunity so long as they're wearing that robe. How is that right? All right, so HB 2675 goes into a little bit more detail as we showed up on the screen briefly. And I have to go through a parade of information, which I will be sharing with you guys, but it's a lot to organize. It's a lot to read through. There's some really great changes happening right now. But I do know that this person who's making this legislator and putting it before his state, he has received a lot of objections to this proposed bill. But a lot of states, as I have read in my last couple of Monday news shows, a lot of other states are beginning to follow suit and demand that these parent bill of rights be accepted and passed and enforced. So let me see. I got the Federalist 83 papers. Separation of powers. Oh my gosh. Sorry, guys. Bear with me. I had it up on my screen. Let me see. All right, let me just. Okay. Okay, so HB 2675 actually has, let me see. Okay, perhaps we will revisit that one. When I do find it, guys, I will leave the link in the show, and I'm sorry that I'm having a little bit more technical difficulties and speech difficulties. Okay, so to finish off our show, I just wanted to go back a little bit more into the importance of, just if you cannot afford an attorney, it is really in your best interest to look at what is holding you back from being able to get those finances, whether it be a bank loan or maybe selling off some of your assets. Unfortunately, to demand that our constitutional and state laws be followed, it's not really getting us anywhere at this point, at least not yet. So we have to think about think outside of the box, think about what is the most important thing that you can do right now to get your children back home as soon as possible. Because once this case starts, it is a ticking time bomb. You are racing against the clock to get your children back home. To share a little bit about my case, sole custody was given to multiple count felon, very abusive man, abusive father. I appealed the case over a month ago, and it still has not been put on the docket. They are in violation of several court orders at this point. The courts are in violation of their own court orders. The officers of the court are also in violation of those court orders. And unfortunately, shouting and getting upset and like one of these complaints was showing, making accusations and retaliating against everybody on the case is not always going to be helpful. In fact, it could hurt you even more. So, be proactive, think creatively, try to figure out other ways that you can get money to hire an attorney. It's not going to be easy. Sometimes the fastest and the easiest solution is not the right solution. In fact, often it's not a solution at all. It's just an idea. It's a pipe dream. So if you want to get your kids home, take a look at your credit. What is on there that is holding you back from getting some kind of loan? What are things that you can do to work with that? Put your pride away, reach out to friends, reach out to family. Your children need you. They are not safe in Child Protective Services. They're not safe with your abusive exes, and they need you. They need you as your parent. They need you to be there, and you have the right to be there. Also, I woke up this morning, instantly got a phone call dealing with some bullshit. Okay. And it's kind of been stockpiling all day at this point. And, when I find myself in a situation where, I feel like, and again, the keywords I feel like I am being wrongfully persecuted for whatever reason. If I know that I hadn't done anything wrong, but I am, facing some kind of issue nonetheless, I always ask myself, what can I learn from this? What can I have done differently? So in this particular incident that went down this morning, I stood my ground, and I was kind of reflecting on it later before the show. And I asked myself, okay, well, what could I have learned from this situation? This was unrelated to my case, but it was a legal situation nonetheless. I've not committed any crimes. I didn't do anything wrong. It was very petty. And the person responsible for this certainly knew better, and would be very ill-informed to pursue any further action. But I'll just leave it at that. So we are amazing human beings. We were not here by happenstance. We fought to come here. We beat out how many other millions of sperm just to fertilize. We survived 9 months in the womb and came out, survived childhood, beat illnesses, all kinds of stuff. Like, we are not here by chance. We are here because we are supposed to be here. We are supposed to be exactly where we are right now. And we did not come into this world to be anybody's doormat. We did not come into this world to be walked all over and taken advantage of people. But it is up to us to stand our ground. It is up to us to fight for our interests, our rights, our aspirations, our happiness, our justice, our liberty. That is up to us and nobody else. And if you don't take that accountability into your hands, your own hands and yours alone, then you can't expect anyone else to help you. You have to take the initiative. Okay. And a lot of times, like, when you complain, nobody wants to help you, So, and that kind of brought me into some further reflection. And I think we're about out of time for today, guys. But I want to share with you this really amazing book. I heard about it before, but I wanted to get it, but I was like, do I want to spend this money on this book right now? And I was grateful and blessed enough to have received a scholarship from my college, because I'm struggling financially as well, guys. I've got things on my credit that I need to work on. The real estate market is crazy. I'm not really getting a whole ton of business right now. I have a modest cleaning business that's picking up because it's spring, but still it seems a lot of the times, like, no matter how hard I work, there's just always so much further that I have to go. But I finally went and I purchased this book with the help of my scholarship, and I would like to share it with you guys. This book is called Can't Hurt Me. Hold on, I'm trying to hold it straight. Okay, so this book is called Can't Hurt Me by David Goggins. And I mean, from the onset, like from the very first sentence, like, I was hooked. Like, he completely skipped all the bullshit pleasantries and he went right into the meat. And it's just, let's see. I'll just read a quick paragraph. Okay. In every town, in every country, all over the world, millions roam the streets, dead-eyed as zombies, addicted to comfort, embracing a victim's mentality and unaware of their true potential. I know this because I meet and I hear from them all the time. And because, just like you, I used to be one of them. And I had a damn good excuse too. Life dealt me a bad hand. I was born broken, grew up with beatdowns, was tormented in school, called the N-word more times than I could count. We were once poor, surviving on welfare, living in government-subsidized housing, and my depression was smothering. I lived life at the bottom of the barrel, and my future forecast was bleak as fuck. And I'm quoting that. Very few people know what the bottom feels like, but I do. It's like quicksand. It grabs you, sucks you under, and won't let go. Okay, so I don't want to ruin the book, but basically it has 10 challenges that it wants you to take. So this book is about mastering your mind and defying the odds. And in a CPS case, what is your number one enemy? Your number one enemy is actually your own mind. You have to fight every day not to succumb to the pain and the pressure of being under siege, being under attack at all angles. And you have to fight to stay strong for your kids. You know, that's not easy. And the second biggest challenge is defying the odds of how a lot of these cases turned out. You know, it's you're up against a really big enemy, and that enemy is very powerful. They are very knowledgeable, and they've been doing what they're doing for a very long time. And they're not going to take kindly to anybody who stands up against them. In fact, this is something that me and the person who is passing the bill HB 2675 were discussing. And he did give me permission to use our content and to talk about what we were talking about. But he was talking about the attorneys, and I'm going to ask if we can play the second video when I'm done with this section. There is a 60-minute video where there was a hidden camera, and this person basically disguised himself as like an African diplomat, and he was coming to America talking to lawyers about how to hide his assets, or basically like, you know, swerve around the law. So if we could go ahead and play that video now. Let me see.
Inadvertently gotten a sassy answer to that question from attorney Mark Koplik in its hidden camera video. Koplik explained to the representative of the phony African minister why he never worried about government subpoenas.
They don't send the lawyers to jail because we run the country.
Do you run the country?
Still do.
I love it.
Still do.
I should say some lawyers run the country.
So you are some of them, two of them.
Yeah, a small amount.
We're still members of a privileged class in this country.
So what does it mean you run the country? Means you...
We make the laws, and when we do so, we make them in a way that is advantageous to the lawyers.
Now, was that not disturbing or what? So I've said in previous shows that oftentimes when we're in these court cases and we've got these court-appointed attorneys, and disclaimer, not all court-appointed attorneys are bad, but there is one aspect of being an attorney that no attorney really wants to talk about. And that is the fact that when you're a licensed attorney, you would think that you work to uphold the Constitution, under which the officers of the court have taken an oath. But that's actually not the case. So according to the National Bar Association, which I have my opinions about them, I will keep them to myself. But the attorneys are actually employees of the courts in the states where their license is held. So oftentimes attorneys who threaten to go against the grain of what these courts are doing to our families are threatened with losing their license. There are also attorneys and politicians who do go against the grain and they start making change, like Nancy Schaefer. And there was another attorney. I need to figure out his story and his name and share it with you guys. But they're dead. People are being murdered for trying to make these changes. So I will do my best to provide you guys as much education as I possibly can. That is my number one passion in life, second to my kids. My children are my number one passion in life, as all of us, you know, I'm sure feel the same way, which is why we're dedicating our time watching these shows and trying to help save them. But second is knowledge. I mean, I'm still moving into my place. There's construction going on still, but I mean, my house is full of books. I read so much. I love reading, but knowledge is power. Knowledge is power. Knowledge is power. And it's not just having that knowledge, it's knowing what to do with that knowledge that is paramount to your success. So I will do everything that I can to help you guys. I wish that I could snap my fingers and just vacate all these bullshit orders and bring our kids back home. But there's so much more work to do than just that. And that in and of itself is damn near impossible. So we got to think out of the side of the box. We have to get creative and we have to keep fighting. And we were not put on this earth to be anyone's fucking doormat, and neither were our children. So we're going to stand up and we're going to keep fighting. Okay. We're going to keep on keeping on. All right. So we have reached the end of our hour today. Join me every Monday at 1 p.m. Pacific Standard Time. That is 4 p.m. my time. I'm on the other side of the coast. Also, I have my show, Fight CPS, The Civil Rights Struggle, every Thursday at 7. If you guys would like to be on the show, if you would like to have an interview with me, please email me at amanda@vincentdavis.com, right over here. And thank you guys all for joining me tonight. Keep your head up. I know you're in pain. I know that what you're going through is so difficult. I've been thinking about my kids very deeply these last few days. I am very, very worried about their welfare. I am very worried that they might not even be in this area anymore. And it seems like the court is just aiding and abetting this man to keep committing crimes. And I feel that the future might be very bleak, but I just have to fight and keep reminding myself to take it day by day. And if I'm not here to fight for them anymore, then who will? You know, so we have to keep going. It's painful. I can't imagine a life without my kids or having to think about how long it's going to be before I see them again. And I know a lot of you are feeling the same way, wondering every day, are they okay? Are they hurt? Do they miss me? Are they going to hate me? You know, when am I going to see them again? So it's very real. It's very real for me, and I know it's very real for you. So we will keep fighting and doing everything that we can. Okay. And with that, you guys have a great rest of your day, and I will see you guys on Thursday.